So I would like to welcome all of you to AmCham Live, AmCham's new webinar series amid the coronavirus pandemic. I'm Peter Kovács, the Communication Manager, and I'll be your host this afternoon. Today's topic is trade secrets, non-competes, know-how protection in light of a pandemic threat, and we have two distinguished guests from BPV Adi Németh Law Office to present it. Dr. Anna Bozás, who is an attorney of BPV Adi Németh, gained a broad corporate M&A, civil law, family, and criminal law experience from a wide range of industry segments. Previously, she worked as a legal consultant at Deloitte and has a strong international law firm background. Dr. Gábor Márki, attorney at law, has demonstrated experience in competition law, M&A, and corporate law, civil, and law. Gábor, the floor is yours. Thank you.
Thank you very much. I also welcome everyone, and I would like to grab the occasion to thank you for joining this seminar. My topic will include three groups. The first one is registered and non-registered intangible assets as holders of company value. The second one is trade secrets and know-how. And the third one is intangible assets and M&A transactions. Throughout the previous decades, physical assets were mostly responsible for company value and were considered to be largely responsible for determining the competitiveness of an enterprise in the marketplace. Recently, this trend has shifted significantly. As service economy is growing and IT revolution took effect, intangible assets are becoming more and more valuable, and in several cases, such as the coronavirus pandemic, they become more valuable even than physical assets. The basic distinction between intangible assets is that whether they are eligible to be registered or not. Both non-registered and registered intangible assets can hold enormous value and can contribute to preserving or enhancing the value of a company in case of a sale, a merger, or an acquisition. One way of making best use of a company's intangible assets is to protect them legally by contractual means, and where they are eligible for the protection of registered IPs, to acquire and maintain registered IP rights. It is safe to say that in several cases, the potential of intellectual property is underestimated by the holder itself. However, when IP is legally protected and there is demand for the IP-protected products and services, IP can become a very valuable business asset. IP can enhance company value by generating income for the enterprise through the licensing or sale of the company's IP-protected products or services, and protected IP rights can increase value in the eyes of investors as well. The foregoing is especially true in the course of sales, mergers, or acquisitions during the current times where coronavirus is sweeping over the earth and has a huge impact on economic relationships as well. Currently, some companies can easily find themselves in a situation where they are in the middle of a transaction process and intellectual property became their sole or primary valuable asset. Non-registered intellectual property rights, trade secrets, and know-how. Even in the case of those enterprises where traditional production techniques remain dominant, the role of intangible assets and know-how among them is also taking center stage. A major part of a company's intangibles is the know-how held by the company, which in most cases shall be necessarily treated as trade secret. Contrary to registered intellectual property rights, such as patents, trade secrets, or business secrets, and know-how among them are protected without registration and without any procedural formalities. However, notwithstanding that know-how in most cases qualifies as trade secret, the subject matter of trade secrets is usually defined in broad terms in the different legal systems. For example, if you take a closer look at Hungarian legislation, the Act on the Protection of Business Secrets declares that business secrets shall include any confidential fact, information, and other data or a compilation thereof connected to economic activities which are not publicly known in whole or in the complexity of its elements, or which are not easily accessible to other operators pursuing the same economic activities where the owner of the secret has taken reasonable efforts that may be expected in the given circumstances to keep such information confidential. Know-how, according to the Act, means technical, economic, and other practical knowledge of value classified as business secret, held in a form enabling identification, including accumulated skills and experience and any combination thereof. Accordingly, broadly speaking, any confidential information which relates to economic activities is not publicly known, its holder made efforts to keep it confidential, is of monetary value, and therefore gives the company a competitive advantage, may be considered as business secret. Manufacturing and industrial information as well are eligible to qualify as trade secrets, and the unauthorized use of such information by any person who does not qualify as holder of the secret shall be regarded as violation of the trade secret. As no statutory restraints are declared in this respect, trade secrets can be protected for an unlimited period of time. Just like as registered intellectual property rights, trade secrets can also be major holders of company value. Their protection should be carried out by way of implementing contractual provisions in civil and labor relationships, in most cases within the framework of much simpler conditions than what is required to have granted registered protection for intangibles that qualify for it. There are certain cases when trade secret protection may be necessary. While practically nearly an unlimited range of issues can be made subject of trade secrets, there are some well-defined cases where trade secret protection seems to be by all means necessary. For example, if the subject of the secret is not patentable, but it qualifies as a major issue and has a significant contribution when it comes to company value. Another case is when the subject of the trade secret is patentable, the company has applied for patent protection, and the registration is in process, but the protection has not yet been granted. When the trade secret, it's a third case, when the trade secret is not considered to be of such great value to be deemed worth a patent, but the company has strong interest in keeping it confidential. It should be kept in mind that legal regulations pertaining to business secrets are different jurisdiction by jurisdiction. Patent or other registered IP protection, where the subject of the secret makes it possible, is able to provide a more effective safety net against unauthorized use or disclosure. What are the possible sanctions of trade secret violation? Before interpreting the sanctions of trade secret violation, it should be determined what kind of acts and omissions qualify as such. Although there is no unified regulation in this respect, neither within the European Union, national laws draw a more or less similar picture in this respect. For example, under Hungarian law, the unlawful acquisition, use, or disclosure of trade secrets qualify as trade secret violation. Taking a closer look, unlawful acquisition means when the acquirer gains access to any object containing the business secret under the lawful control of the owner, or from which the business secret can be deduced without authorization, including unauthorized access to, theft of, or copying of any such business secret. Unlawful acquisition also means where access to the business secret is obtained without the consent of the owner by any other conduct which is considered contrary to honest commercial practices and fair dealing. Use or disclosure qualifies unlawful when it is carried out without the consent of the owner. Trade secret violation can be sanctioned basically in two ways. On one hand, the parties are free to determine penalty payment obligations, entitlement to immediate termination, or any other sanctions in their contractual relationships. On the other hand, trade secret violation can be subject to judicial remedies as well. If the violation is proven at court, a court order can restrain the person from further benefiting from or misusing the trade secret, can determine monetary compensation in the form of damages based on the actual loss caused as a result of the misuse of the trade secret, for example, by way of lost profits or by way of unjust enrichment. And also, a court order may order the destruction of the products made by the infringing act, or order the destruction of the equipment used to carry out the infringing act. Another really important topic is intangible assets and M&A transactions. Recent reports assessing deal values all over the world show a rather unified picture on the composition of the purchase price of enterprises. In most cases, a major part of purchase price paid for companies of different kind lies in the value of intangible assets. In the course of a transaction, the purpose of the acquisition agreement is to identify the issues essential to the specific transaction, such as the stock or assets, the purchase price, the method of payment, the date of closing, and any conditions precedent which the seller or the buyer is expected to meet prior to the closing date. Additionally, in the specific context of intellectual property, the seller will usually be asked to make certain representations and warranties in connection with the intangible assets to be sold. In this respect, business quota purchase agreements tend to emphasize the representations and warranties concerning the validity of the intellectual property and to identify and schedule all the intellectual properties subject to the transfer. The representations and warranties to be incorporated into a typical sale purchase agreement is likely to be one of the more heavily negotiated aspects of any deal. Typically, included by a seller in its representations and warranties are statements to the effect that the schedule of intangible assets is complete and accurate, it is the rightful owner of such intangible assets, no liens or encumbrances exist with respect to such intangibles, the intellectual property does not infringe the IP rights of a third party, the buyer is indemnified, seller will assist buyer in performing due diligence in connection with the IP being transferred, and any other disclosures. As I pointed out earlier, the value of intangible assets is a major factor in determining the purchase price of a company. Therefore, at the time of the coronavirus crisis, special attention should be given to representations and warranties stipulated during the course of transactions with a view to such assets. If the share purchase agreement has already been signed and representations and warranties have already been stipulated, the seller may check whether any of the respective warranties are exposed to any incidental breach in connection with the changed circumstances due to the COVID crisis. As the reps and warranties shall be repeated in most cases upon closing, the sudden changes may put seller in a breach, which situation should be handled sooner than later. In case if the deal is still in negotiation phase, purchasers may consider to address specific issues in the form of warranties for intangible assets, for example, regarding the preservation of company goodwill during the COVID crisis. As far as sellers are concerned, it may be expedient to disclose as much information regarding coronavirus-related setbacks as possible to avoid responsibility in the form of warranty breaches. I thank you very much for your attention, and after a short technical break, I will pass the word to my colleague Anna.
Thank you, Gabor.
Thank you very much, Gabor, and I myself also would like to welcome everyone, and I'm going to guide you through the possible ways of ensuring our trade and business secrets in our employment relations, which is more and more important, especially in these unprecedented times. In my presentation, I will mainly focus on employment relations in the view of our main topic. As you can see, we will discuss how to protect our trade and business secrets in our employment relations, how to improve employee loyalty, and how to enforce a non-compete agreement. As you will see, or probably you already know, non-compete agreements are the most controversial of restrictive agreements, but also the most effective in preventing unfair use of trade secrets, if they are enforceable at all. And that's a big if in some cases. The first thing to do is to identify the trade secrets. As Gabor already mentioned, there are three basic requirements for any information to be considered a trade secret and thus to be legally protected. The first one is that the information must be secret or shared in a context of confidentiality. And the second one is that the information must have commercial value by virtue of being a secret. And the last one is that the owner of the information should have made reasonable efforts under the relevant circumstances to keep the information secret. Trade secret may be any type of information, such as formula, devices, financial information, business plans, client list, etc., that the company considers to be valuable and offers it an advantage over its competitors. Given today's progress in communication technologies and the speed at which information can be duplicated and moved, maintaining a trade secret is an everyday challenge. To meet this challenge, a company must consider the following. As I mentioned, it should identify all valuable trade secrets and develop and put in place a trade secret protection policy and program. Educate employees about the importance of trade secrets and communicate to them the policy and the program itself. Carefully decide and review periodically as to which employees need to know or use the information and restrict access to the trade secrets on a need to know or need to use basis. Apply physical and technological restrictions to access trade secrets, and last but not least, sign confidentiality agreements with all the relevant employees and also with outsiders who in one way or another may get access to the company's trade secrets. The last recommendation leads us to our next topic, that our employees are the biggest threat. I know it sounds a bit harsh, but I will explain why is it true and how to change the premise, therefore how to improve employee loyalty. There is always a psychological contract between the employer and the employee. It's different from the legal contract. It is a set of expectations that both the employees and the employer have concerning each other's contributions to the company. These expectations are mostly learned and understood while working together day by day. An employee automatically owes confidentiality to the employer. However, in an environment where employee mobility is high, these psychological contracts are no longer reliable. It implies that giving formal legal contracts a greater importance becomes more and more crucial. Such contracts or clauses in contracts enhance legal protection of trade secrets and provide a company security in case of litigation. There are several types of contractual clauses in employment agreements that an employer can enter with its employees to protect its confidential information. These are particular, but not exclusively, the following. The ownership of IP. This clause is one that makes it clear that any intellectual property created by an employee in connection with the employment is solely the property of the employer. The return materials. It is a straightforward but important provision that should be in every employee agreement. Not surprisingly, these provisions require a departing employee to return all records, property, or information obtained or created by the employee in the course of his or her employment, regardless of whether the information is confidential or not. The enforcement of this clause is relatively easy because there is no need to prove that the information qualifies as a trade secret or was even used. Non-disclosure agreements. According to the general rules of the labor code, employees are obliged to keep confidential and business information during and after the employment relationship, and also obliged to refrain from any activities which may infringe or jeopardize the economic interests of the employer. Although, apart from the legal background, at a bare minimum, employers should have all employees sign non-disclosure agreements because they highlight the important obligation that all employees have to protect the company's valuable information. The conflict of interest clause. Under the conflict of interest clause, the employee agrees that during the term of the employment, he or she must not engage in any work, paid or unpaid, that creates an actual or potential conflict of interest with the company. Such work shall include, but is not limited to, directly or indirectly competing with the company in any way. And the last contractual clause, which I would like to talk to you about, is the non-compete agreement. Trade secret theft is often an inside job. Studies show that historically, the vast majority of trade secret violation is by insiders, typically employees or former employees, and so the threat to the company's trade secrets is very real. Employees know they are about to leave for a competitor, or they know that they are about to start their own competing business, and they will sometimes try and get an unfair advantage by taking their employers' confidential information, such as customer lists, strategic plans, etc., and they're going to have to leave the firm. This is what companies are understandably seeking to avoid. Generally, employees are a main threat because there is no guarantee that a non-disclosure agreement and even a non-compete agreement will be sufficient to prevent the use and unauthorized disclosure of secret information. In any case, a non-compete clause is not an absolute guarantee. It is often bound by restrictions on its duration as well as geographic limitation. And also, according to the general provisions of the Labor Code, the parties may conclude a non-compete agreement for only up to 2 years following the termination of the employment in order to protect the economic and business interests of the employer. In exchange for honoring the employee's obligation, the employer shall pay proper compensation to the employee, which cannot be less than 1/3 of the base salary due for the same period. The parties may specify the details, but the prohibitions must be appropriate and appropriately restricted with regard to place, time, and scope, such that it does not unfairly compromise the employee's future economic activity. It shall also be highlighted that specific confidential information must be separated from the ordinary skills and knowledge that the employee had developed while in his former employment. He or she cannot be prevented from using the latter information. The key issue here, however, is to ensure that our non-compete agreement covers every relevant field where our employees could harm our business interests. Moreover, besides the restrictions, penalty is the other key factor of the agreement, as we all seek to prevent a possible breach, because when it happens, we cannot guarantee that our secrets are safe. Therefore, in order to prevent the breach of contractual obligations, the parties shall determine different legal securities, bearing in mind that the provisions of the Labour Code cannot be disregarded, as the agreement and the enforcement of the obligations are governed by the labour regulations. Such legal security may be an obligation of the employee to inform the employer about his employment status during the secured period, or to stipulate a contractual penalty. According to the Labour Code, the employee may pledge to pay a certain amount in case he fails to perform non-compete clause. In accordance with the essence of the non-compete agreement and the relevant legal provisions, it can be stated that an obligation to pay a contractual penalty occurs only if the employee commits a breach of contract, thus the employee establishes the new employment relationship. And by stipulating a contractual penalty, the employer may effectively prevent the employee's breach, as it follows from the nature of the penalty as a lump sum compensation, that no proof of damage is required for its enforcement, thus it becomes automatically due if the employee breaches his obligations. The other possible way to prevent such breach is to explicitly state in the agreement that the employee is required to declare his or her new job and employment during this period. Moreover, nowadays it is easier to monitor compliance with the non-compete agreement, as the employer may seek information in that regard via the internet as well, particularly through online professional social networks. But you may be wondering, what does all have to do with the impact of COVID-19? Nowadays, when the COVID-19 pandemic and the government's day-to-day response rules our lives, the enforcement of our disputes have dramatically changed. The courts have changed their procedural rules, yet online trial has remained a matter of imagination. There is also a practical issue of whether a court will even entertain an enforcement proceeding right now, and the likelihood that the cases will move very slowly once the restrictions are lifted. In short, the enforcement in the time of COVID-19 is tricky at best, impossible at worst. When a non-compete clause is challenged, in addition to the scope of the restriction and the employer's legitimate interest being protected, courts also take into account interest of the public and also the interest of the employee, and both interests are implicated by the impact of COVID-19. With so many employments have terminated and others having concerns that their employment is in jeopardy or having experienced significant pay cuts, it is likely that at some point during or after the pandemic, a segment of workers will move to new positions. In today's climate, now more than ever, employers who are looking to enforce non-compete agreements, as well as employers hiring new workers and looking to enter into new non-compete agreements, need to understand not only whether the agreement in question can be enforced, but whether it should be enforced. In this regard, companies need to think carefully about the potential weight the courts may give to the employees and the public interest due to the pandemic, especially when seeking a preliminary injunction, because the courts will surely take into account how hard it is likely going to be for unemployed workers to find new positions. These uncertainties lead us to place the focus much more on our employees' loyalty in the future. It is therefore time to pay greater attention to build employee loyalty as a tool for protecting trade secrets. Communication is important, so mutual expectations should be crystal clear to make sure all parties understand what is expected from them. Listening to the employees is also important in making them feel relevant to the organization, and it can also alert a company to weak links and pools of dissatisfactions, which would enable management to take timely remedial measures. In light of the foregoing, it is a practical advice that if you do have workers who have access to your trade secrets and they have not been let go, make sure that you stay close with them and reassure them about the long-term health of your business and longevity of their positions, because employee loyalty is as important as customer loyalty. Nevertheless, if you cannot avoid the termination, It is essential to conduct an exit interview where the employer would remain an exiting employee about the post-employment obligations to maintain the confidentiality of trade secrets and the consequences of a breach of these post-employment obligations. Such exit interviews are also beneficial to an employer as they might acquire information on the future plans of the former employee, such as where the employee plans to work. This information will help employers understand better the potential threats to their trade secrets and identify the competitors. All in all, our conclusion is that when identifying trade and business secrets, the companies must build a strong protection system around such information. Companies are thus advised to establish strong psychological loyalty with its employees to stand a better chance of seeing its non-disclosure and non-compete agreement being effective and thus safeguarding its trade secrets. These were actually the topics that we wanted to share with you. Now we are happy to discuss if you may have any questions.
Thank you, Anna. Thank you for the very informative presentation. I think we all learned a lot about this. I would like to give the opportunity to the guests to now ask their questions. In which cases the disclosure of a business secret does not qualify as a business secret violation?
Okay, that question belongs to my topic, as I see. Practically, the acquisition of business secret shall not be construed an infringement in three basic cases, which happen to be in most of the legislations of at least EU member states. For example, one case is when the business secret is disclosed by an employee as part of exercising his or her right to information and consultation. The revealing the information, the secret information, is legit in this case to the extent necessary in order to exercise the rights of the employee. Another case is, for example, when the acquisition of the business secret was done for the purpose of protecting the general public interest. This is provision which often appears in the business secret clause of contracts. And another case is, for example, when the acquisition, and this is something that is declared by law, by the Act on Business Secrets, where the acquisition, the use, or the disclosure of the business secret is prescribed or made possible by a directly applicable EU legal instrument.
Thank you. Anyone with a question? What happens if an employment contract is terminated, but the employer doesn't want to maintain the non-compete agreement any longer?
It is a very good question because, as we see it, it is a tricky part in this type of agreements. Because although the essential rules of the non-compete agreements are laid down by the labor code, as I said earlier, but the provisions of the civil code should also be applied, as the core rule of unilateral termination is in the civil code. Because according to the civil code, any person who has the right of withdrawal by the law itself or on the basis of a contract, then it may terminate the agreement by its unilateral act. The Labour Code stipulates the right for the unilateral termination only in respect of the employee. Thus, the employer may only withdraw from the contract if the agreement contains such clause. And even in this case, the employer can only exercise its rights until the termination of the employment has not been executed yet. Because after the termination, it is not possible to do so, even if the employer could demonstrate that it has no interest in maintaining the clause. All in all, there are two red flags for the employers when engaging in non-compete agreements. The first one is to make sure that the agreement empowers the employer to withdraw from its obligation. And the second one is to withdraw before the employment itself would be terminated. As regards the possibilities of the employee, it is much more extensive, as the Labour Code itself provides a legal right of withdrawal for the employee, according to which an employee may withdraw from an agreement if he or she lawfully terminates the employment with immediate effect. In this case, lawfully is the key word, because as the judicial practice highlighted, if the termination is challenged by the employer, of course, then the employee and the employee would fail to demonstrate the merits of the termination, then the withdrawal will be null and void also.
All right, thank you. Now, dear guests, does anyone have any questions? One last question, perhaps? Well, if not, I think it's time to close up today's webinar. I would just like to show you our next webinar, which will be held on the 23rd of June at the exact same time period with Professor Arpad Rab, titled "How has our life changed since the coronavirus pandemic, and what are the lessons we can learn from it?" So I would like to urge you to sign up for this wonderful upcoming webinar, and I would like to take this opportunity to thank our lawyers from BPV Yadin Nemet Law Office. Thank you for this fascinating presentation, and it was nice to work with you guys on this. Hopefully we'll see each other soon in the office, and take care. For more news about AmCham, our upcoming events, useful information about the pandemic, please visit our website. And I wish you all to stay safe and healthy. Enjoy the rest of your day. Thank you all.
Thank you very much.